Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Pilta and Meshegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, happy Thursday. Aloha. Aloha, my friends. Welcome to this last minute live. Rosemary Scapacchio is going to be on fire today in the Myles King case. We're going to watch the Zoom because I think it's going to be Judge Doolin. Doesn't say the judge on the calendar. Here's the thing. First of all, how about those Knicks? You know I'm not a basketball fan. But I was with my boyfriend, Dave Matthews, last night, like within feet of Dave Matthews last night. If you follow me on Instagram, you will see everything on my Instagram, all the clips and things. I can't play the music on this channel, but I was really close to him. I'm just saying it was amazing. It was a great night. But because it was at an outdoor venue, Forest Hills, which is the old Forest Hills tennis stadium where they used to have the US Open tennis, it's in a residential neighborhood. And so there's a hard stop at 10 p.m. The concert ended at 9:30, and so we were able to go to a nearby restaurant to watch the rest of the game. And oh, what a nail biter. Holy crap. In the last second, the Knicks pulled it off. It was wild. Okay, here's what's going on because we had so many things to do. And then I already had a 5 o'clock show scheduled. Haven't decided what to do it on yet, except I think I want to do the Adam Montgomery. Adam Montgomery has been granted a new trial by the Supreme Court of the state of New Hampshire, and that's wild. So a lot of you wrote to me about that, and I think that's what we will make the show about at 5 p.m. Here's what's going on in Myles King, and I'm going to, as you see scrolling at the bottom, when people come in and say, why isn't Melanie talking? Here's why. Because people who go on the Zoom themselves do not know how to mute. We heard Brandon the other day, remember? Brandon dropping the F-bomb at the Karen Reed civil hearing or the defamation hearing. I'm not even really sure. I didn't party with Taylor Swift because I was not at the Knicks game. I was just watching it on TV. But she did hug Mariska Hargitay, and they had T-shirts on that said Stevie Nicks, K-N-I-C-K-S. It was fabulous. We'll have to talk about that later. But don't distract me because I have to stay on topic. Rosemary Scapacchio, the Commonwealth is making a motion in the Myles King case. Remember Myles King? He is the guy who they let out on bail because Proctor and Lally didn't turn over any discovery on his murder case. They let him out on bail after he 4 years. He was in jail for like 4 years. And then while he was out on jail, he got picked up on federal drug charges. And now he's back, I think, in federal holding. The Commonwealth and Rosemary Scapacchio both have agreed in they call it an assented to motion, meaning they both agree on this motion that the Myles King's second motion to dismiss, because they made another one recently, remember, because of a Proctor's phone extraction that was released, that it should be unimpounded because the Commonwealth is saying we can't even respond to this unless portions of it are unimpounded because we need to refer to those things in our motion, right? So the Commonwealth and Rosemary Scapacchio, who represents Myles King, have agreed that everything should be unimpounded. But wait, Michael Proctor on his continued privacy tour has jumped in and said, oh no, no, I have privacy rights and you should not violate my privacy rights because it's going to be really embarrassing to me if you release portions of my phone extraction. Here's the opposition, because we're bumping up on 3:00. And so I want to get at least one of the papers in for you. But it's just enough to tell you that the Commonwealth agreed to this motion, and it's Proctor who's coming in. Okay. Third party, this is Proctor's now opposition to the agreed upon motion of Rosemary Scapacchio and the Commonwealth to unimpound portions of Proctor's phone extraction because they need to oppose this motion to dismiss. Here's Michael Proctor's limited opposition to the Commonwealth's assented to motion to unimpound defendant's second supplemental motion to dismiss. And he is saying here, I'm asking that the court deny the Commonwealth's assented to motion to unimpound defendant's second supplemental motion to dismiss. They're trying to tongue tie me already this morning. He continues to say, as grounds, therefore, Proctor states, the unimpoundment of said data would certainly compromise Proctor's privacy interests. Really? How did you feel about the privacy interests of those women whose nudes you were sharing and the SA victims whose identity you were sharing? But now he says the unimpoundment of said data would certainly compromise Proctor's privacy interests and possibly those of other individuals referenced in the data. Like who? The other misogynistic bigots and anti-Semites that you were texting? Yeah. Doesn't work that way. And racist people. As noted in the Commonwealth's motion, Proctor has previously raised these objections before this court. While Proctor understands the appropriateness and necessity of communicating in a forthright manner and the victim's family members about the nature and context of defendant King's motion to dismiss, Proctor, if the Zoom starts, I'm going to just mute myself. Proctor has legitimate privacy interests at stake surrounding the unimpoundment of this sensitive data. Unimpoundment of defendant King's motion will only add further public scrutiny to Proctor's private cell phone data and would result in further and unwarranted intrusion into Proctor's private life. Wherefore, Mr. Proctor respectfully requests this court deny the Commonwealth's motion, and it is XOXO by Matthew Hamill, who's the attorney we saw in court for him the other day in the other case, in the Karen Reed case, and Thomas DeGangi. Another argument that the defense made was like, listen, we need to talk to the family, or the Commonwealth made, I'm sorry. We need to talk to the family of Marquise Simmons, and we need to explain to him what these texts, Marquise Simmons is the alleged murder victim of Myles King. Well, he actually was killed, but, innocent until proven guilty. The Commonwealth needs to talk to Marquise Simmons' family, and under the current protective order, they can't do that. They can't explain to them what's in Proctor's phone because it's currently under a protective order. And so, yeah, Proctor has no more private life. People are saying, like, it's wild. Proctor was supposed to be working for us, says Mal, and we should be able to see everything he has done. I mean, the family of Marquise Simmons should need to know what the difficulties are going to be with the criminal case against Myles King, right? And it's wild, and it's just, par for the course with Proctor. He doesn't care about anybody else's privacy. He didn't care about Karen Reed's privacy when he was sharing her private medical conditions with his buddies, calling her a whack job C word, etc. So, but we should all feel sorry for him. He's on the world.
And everyone is being recorded from now on. Yeah. Good afternoon. This is the Zoom for Norfolk Superior Court. We're going to get started on the Myles King case momentarily. You would just remain on mute if you are not one of the parties. And could someone give me a thumbs up that you can hear me? Thank you. I appreciate it. And have one more person joining. Is everyone here that needs to be here for the Commonwealth?
Yes, yes, Ms. Salem.
Okay, and for defense, do we have everyone that we need?
I do not see Attorney Scapicchio.
Okay, and then I do see Attorney DeGangi for interested party. Hello. Okay, well, we'll wait a second. Thank you. Good afternoon. And Attorney Scapicchio is in the waiting room. Here we go.
What? All right, please.
Good afternoon, y'all. This is Commonwealth versus Myles King, 21 CR 320. Mr. King is not present. I believe Attorney Scapicchio was going to waive his presence. If the parties could please identify themselves for the record.
Good morning. Good afternoon, Your Honor. Jennifer Hickman on behalf of the Commonwealth.
Hi, Attorney Hickman.
Good afternoon, Your Honor. Rosemary Scapacchio on behalf of Mr. King.
Okay, good afternoon, Attorney Scapicchio.
Good afternoon, Your Honor. I'm Tom DeGangi. I represent third party Michael Proctor.
Okay, good afternoon, Mr. DeGangi. Attorney Hickman, I know you filed a motion, and I know that Attorney Scapicchio has assented to it. Just for the record, Attorney Hickman, just tell me what you're seeking to do.
Your Honor, what the parties have agreed to is in regards to the defendant's second supplemental motion that the redactions to attachment B would involve redacting the phone numbers of the WhatsApp handles to the individuals that are on a WhatsApp chats that are attached in attachment B. The parties have agreed to the redactions. I provided that to the defendant. I believe they assent to those redactions. So that there's also a USB drive, Your Honor, that was attached. My understanding is it contains the discovery that the Commonwealth has provided relative to Mr. Proctor's personal phone. The parties agree that that will remain sealed, Your Honor.
Okay. Attorney Scapicchio, you agree?
Well, Judge, I objected to the protective order in the first place. I've been objecting to the protective order for 18 months here. So I never thought there should have been in the first place. There's no reason to protect Mr. Proctor. So I don't have any objection, Judge.
Okay. Let me hear from you, Mr. DeGangi.
Thank you, Your Honor. First of all, I'd say that we think it's entirely appropriate in this for the Commonwealth to communicate with the victims in this case. We think it's a matter of necessity. Mr. Proctor has done that himself throughout his entire career as a state trooper. However, we think there's an alternative course of action for the Commonwealth to take here, rather than letting these private text messages and Snapchat messages becoming public. And that is for the Commonwealth to simply relay the information verbally or orally to the victims and the victim's family and describe for them the nature of what's contained within these text messages. Your Honor may be aware that there was a lawsuit filed last week by Karen Reed down in Plymouth County. It certainly generated an extensive amount of media coverage. That document is a matter of public record, and I would suspect that some of the information contained within Attorney Scapicchio's second motion to dismiss is already out there. So in that sense, I do recognize that, quote unquote, the cat is out of the bag. However, we're talking about the privacy interests of Mr. Proctor. Your Honor knows he spent his entire professional career working on behalf of victims in this Commonwealth, trying to resolve crimes. He's never been convicted of a crime. Unlike many of the people that have appeared before the court on this matter, he's never been indicted. He's never ever been arrested or had his bail revoked. And I'd suggest to Your Honor that he does have a legitimate privacy interest in these Snapchat messages. They're all from his private phone. And I think there's an alternative avenue for the Commonwealth to take here. At the same time, as I indicated in my limited opposition, we recognize and are grateful and assent to the Commonwealth's efforts to keep the USB drive under seal, as well as the Commonwealth's efforts to redact the telephone numbers. But again, I think Mr. Proctor does have legitimate privacy interests. Some of these motions, and I won't say Attorney Scapiccio's motion, but some of the litigation that's gone on surrounding this Mr. Proctor's cell phone is intended to, I'd suggest, necessarily defame him, Your Honor, and perhaps inflame public opinion against him. So that's the basis for my limited opposition, Your Honor. Thank you.
Okay.
Can I
Attorney
respond?
Hickman, yeah, just give me a minute. Attorney Hickman, none of this information that would be released in any way violates the federal protective order, am I correct?
Correct, Your Honor. This was all material that was taken from the personal order, personal phone of Mr. Proctor pursuant to your original order, Your Honor, in June of 2025. And then in August of 25, we had a second order in which Judge Krupp put time parameters as to the production and the extraction. So the materials at issue here, Your Honor, was only obtained pursuant to your order in June of 25.
Okay. All right.
Your Honor, may I respond?
Anybody else? Yeah,
Yes.
Go ahead.
So first of all, I don't think that Mr. Proctor has any standing here to even intercede in this case, Judge. He is a witness in a case. He's a member of the Commonwealth. He was a member of the Commonwealth's team. If we start letting every witness who doesn't want their information to become public to have standing in these cases to file motions and to be heard before the court, it's going to change the whole complexity of how we try cases, Judge. There's just no basis for him to intercede in this case or in any case in which he was the chief agent or one of the investigatory agents. He is an agent of the Commonwealth.
I think, hold on, you're frozen, Attorney Scapicchio.
Anything to do with creating these texts. He did this on his own. And at this point, from what I've read in all of the internet, in the pleadings from the Karen Reed case, it's all out there. Everything that we are looking for is already before the public. So continuing to seal it in our case, Judge, where, my client has a right to be heard and a right to be able to file these motions unsealed. I don't think that there's any need to seal it. The Commonwealth is the one who moved for this case to be sealed, this information to be sealed. They're now agreeing that it shouldn't be unsealed. I just can't, for the life of me, understand how Mr. Proctor gets standing to even get before the court, Judge, because he has none.
Okay. Thank you all. I'll take it under advisement. I'll have something for you.
Judge, there is one issue that I want to bring to the court's attention. I had read an email too quickly earlier today. The clerk had asked me whether or not I assented to a motion to unredact or to vacate the sequestration order. I did reach out to the clerk. I said I had no position. I thought she was talking about this motion that we were hearing at 3 o'clock today. I did not realize it was a motion to vacate the sequestration order. I just received that motion from the Commonwealth literally 10 minutes ago. The conversation that I had with the Commonwealth was to amend the sequestration order to allow them to speak to 2 witnesses about my filing, but not to vacate the order in its entirety. So I just want to make sure the court understands that to the extent I sent that email saying I didn't have any position, I was referring to today's hearing at 3 o'clock, not the motion that they just filed recently, Judge.
Okay. Yeah, I think that's going to have to go in front of Judge Krupp because that was his order. So if you want to in any way revisit that, I think Judge Krupp would be the one to hear that. He's coming down here in July, and he's obviously available to you over Zoom as well. I know he's sitting in Boston. Okay?
Thank you, Ron. I appreciate it.
Yeah, go ahead.
I did reach out to Judge Krupp, so he knows it was a rare mistake. And he asked that you file your opposition within the next week.
Thank you. I appreciate that.
Okay. Thank you all.
Thank you, Your Honor. Thank you, Madam Clerk.
Thank you.
Okay, so Rosemary coming in hot. Judge Doolin is going to take it under advisement, which means that he is going to issue his ruling at some point in the future. Didn't want to do it, I guess, before, from the bench. But let's take a look at the original. Let me get this banner down. From the original papers, because we didn't get to that while we're here. Can you believe, first of all, why is Proctor's attorney sitting in the dark? I think that man might be in the dark in more ways than one. I don't know. Just maybe. But it's all right. I'll be here all week, folks. I'll be here all week. Here are the originals. So we looked at, if you weren't here, if you tuned in late, because this was totally unscheduled. I just realized that this was happening. I was with my daughter at the dentist. I didn't know if I would be back in time to be able to cover it. And so I did. And we watched the Zoom hearing. And so now we have to go back and look at the original papers that were filed by the Commonwealth and Rosemary Scapacchio on behalf of Myles King. So this is in the Myles King murder case, which has been delayed for more than 4 years, resulting in Myles King filing a bail application saying that Proctor and Lally never turned over any discovery. They've been jerking around with things that they've had in their possession for years and years and years. So Myles King applied for bail. He was granted bail. And then we covered this too. I think it was about a month ago. Myles King was arrested by the feds on alleged drug charges. So they got him one way or another. One way or another. We're going to find you. We're going to get you. But, that's the risk that you run when you have potentially very corrupt law enforcement investigating cases. And what we looked at yesterday is that now the head of all of the public defenders has asked not only the Massachusetts State Police, but also Michael Morrissey to give them a list of every single case that Michael Proctor was involved in, every single case that he was involved in, because they all want to see if their clients were impacted as well. And since based on the limited text message threads and voice messages that we saw that were revealed in the Karen Reed filing, the recent Karen Reed filing against MSP and Canton Police Department, we know that Michael Proctor said lots of other things in his voice messages, including that he'd be willing to cross the line and potentially plant evidence on a suspect, like a bag of Coke, stick a nightstick up somebody's butt and just bring him in. Bring him in. Here's what this hearing was about. This is a motion that is assented to, meaning both sides agreed on it. So it's not really a motion. They didn't really want the court to decide this because they both agreed that this is the way it was supposed to be. But as you know, the judge has wide discretion and always has the final say in matters such as this. And then, of course, Michael Proctor chimed in as a non-party and said, no, I want my privacy. Here is the assented to motion to unimpound defendant Myles King's second supplemental motion to dismiss. This was filed on Tuesday, June 9th, and the hearing was today. The Commonwealth respectfully requests that this court unimpound the defendant's 31-page second supplemental motion to dismiss, docket paper 217, and to the extent necessary, modify protective orders regarding a former trooper's personal phone. Footnote 1, which reads, the defendant's motion was accompanied by attachments and a USB drive containing all of the discovery related to the former trooper's personal phone provided by the Commonwealth. The impoundment/filing under seal of the USB drive, which includes discovery information governed by court order and protective orders, should not be modified, and the USB drive should remain impounded/under seal, as it includes materials that should not be available for public inspection, including private information about third parties unrelated to the issues raised in the defendant's motion, including images of intimate body parts of third parties and highly personal and personal identifiable information of third parties. Attachment B of the defendant's motion should not be unimpounded unless third-party phone numbers are redacted. As to the images, as to the image of minors on page 6 of the defendant's motion, it appears to have been in the public domain for decades. I don't recall now what image of minors this was. There's been so many motions, so many exhibits, and so I'm not sure who those minors are. But apparently it's been in the public domain for decades. Was it Colin Albert at the wedding? I don't really know. The primary issue in the defendant's second supplemental motion to dismiss concerns information derived from an extraction of a personal phone of a former trooper involved in the investigation of this matter. The defendant's filing was under seal/impounded because the materials on the personal phone were produced to the parties pursuant to court orders and are covered by protective orders. Because it is not possible to address the issues raised in the second supplemental motion to dismiss without referencing information on the personal phone, the Commonwealth anticipates that when it files its response, it would need to similarly file under seal absent court order. And again, they don't even mention Proctor in this filing, right? They just keep saying former trooper. And they're not asking that the entire USB drive be released. Just certain things. So let's keep reading. Relevant background. On May 28th of 2025, already a year ago, the defendant filed a motion for an order to preserve a former trooper's personal phone records. Footnote 2, docket number 91, footnote 2 reads, this motion references orders and pleadings in this matter, Commonwealth v. King. Similar pleadings and orders were filed in other pending criminal matters. Yes, I think there was at least 7 or 9 cases involving Proctor that were coming up for trial. But imagine all of the prisoners that are currently incarcerated that had Proctor investigating their case. It's all coming out. The house of cards is falling, in my opinion, and it is explosive. It's going to be explosive. On June 17th of 2025, the former trooper was ordered to preserve his personal cell phone and all data on his personal cell phone and provide his personal cell phone to the Commonwealth and disclose the carrier for the personal cell phone. And that was an order of Judge Doolin on June 17th of 2025, which was right after Karen Reed's acquittal. Or was right around the same time of Karen Reed's acquittal. The June 17th of 2025 order specified that defense counsel shall not show or provide the communications produced pursuant to this order to anyone else, except that defense counsel may show, but not give them to the defendants in this case. So they were allowed to show them to their clients, but they couldn't have copies of them to review while sitting in jail or at home if they're on bail. Footnote 3, which reads, the order also noted that the Commonwealth may move for appropriate protective orders for the court's review prior to producing the aforementioned items and information. On July 25th of 2025, the former trooper moved for clarification of the June 17th, 2025 order and represented that he had changed phones in February of 2024. This is Proctor. And that an enabled auto delete feature on his new phone deleted the contents every 30 days since activation. That's right. That's what his lawyers said. Now his lawyer's coming back and asking for his privacy because he was wrong. Michael Proctor was wrong. The former trooper moved for a protective order as to attorney-client and spousal communications and for clarification of the time period encompassed by the order. Then on August 13th of 2025, Judge Krupp issued an order clarifying the examination of the former trooper's personal cell phone. The August 13th, 2025 order noted that the obligation to produce any data that constituted investigative material or is favorable to the defense was not limited to a particular date range. Krupp was like, yeah, no. I'm not going to limit it to any date. Whatever they can get off that phone, they're going to get. And quite frankly, this is Proctor's attorney's fault because he's the one who moved for an order to clarify, I believe. Yeah, the former trooper moved for a protective order. And then Judge Krupp said, yeah, no, I'm not going to limit it to certain dates. Whatever's on there, they can have. The order required the former trooper to provide his personal phone to the Commonwealth by August 25th, 2025. The Commonwealth to extract a full digital copy of all data on the phone by September 5th of 2025 and provide a copy to the former troopers counsel, who was given 21 days to identify any communications protected by the attorney-client or spousal privilege, after which time the Commonwealth was permitted to search the extraction to locate information authorized by the initial order. Footnote 4. Let's go back to footnote 3, which reads, the order also noted that the Commonwealth may move for appropriate protective orders for the court's review prior to producing the aforementioned items and information. Footnote 4 reads, the judge also ruled on a request regarding attorney-client or spousal communications and found that the former trooper had a legitimate interest in protecting such communications where a valid privilege existed. On October 17th, 2025, the Commonwealth filed a notice of discoverable information under Mass Criminal Rule 14b2 and motion for additional time to complete review of former state police trooper's cell phone, in which it reported that review was not complete because of the unexpected volume of files discovered on the phone. Oh yeah, we covered that when it first broke. On October 24th of 2025, the Commonwealth moved for a protective order restricting dissemination of the materials from the former trooper's personal phone, as the data spanned many years, included images of intimate body parts of people not participating in chats, screenshots of Facebook posts by non-participants, images of non-participants, the full phone numbers and email addresses of text and email chain participants, and the name of a sexual assault victim. The court, Judge Krupp, allowed the motion the same day. Remember, they said they found hundreds of thousands of items on Proctor's phone. And I think Rosemary Scapacchio at one point said recently, or back then, I can't remember, that the printout of Proctor's phone was something like 44,000 pages. On December 4th of 2025, the court, Judge Krupp, ordered that counsel for the town of Canton and the Peace Officer Standards and Training Commission, POST, could receive a copy of the discoverable materials from the former trooper's phone, subject to a protective order. On December 10th, 2025, Judge Krupp modified previous orders to allow materials subject to the protective orders to be shown to counsel of record, their associate attorneys, paralegals, administrative assistants, investigators, and experts assisting counsel. That order also provided that counsel was permitted to show, but not give, portions of the investigative materials to those whose counsel has a good faith basis to believe are necessary to investigate misconduct by law enforcement or bias towards persons in protected classes, and that discoverable materials could not be disseminated outside the criminal proceedings absent further order of this court. Footnote 5. This is a great procedural history for those of you not familiar with the lore behind Proctor's phone extraction. Footnote 5 says, on January 29th, 2026, the Commonwealth filed a motion to provide, pursuant to a civil subpoena, information derived from the former trooper's phone. They have not mentioned Proctor's name once, right? To litigants in a civil action. On February 5th, 2026, the former trooper filed an opposition to the Commonwealth's motion to provide information from his phone in response to the civil subpoena, arguing privacy interests and that neither the Commonwealth nor the civil litigant could establish that the release of information from the personal cell phone would serve the interests of justice in the civil matter. On February 26, 2026, Judge Doolin allowed the Commonwealth's motion and ordered that counsel for the civil litigants could receive a copy of files determined to be discoverable bias information from the personal phone, that the materials could not be disseminated outside of that litigation, and that the Commonwealth could separately redact the names of an SA victim. After subsequent filings by one of the civil litigants and the Commonwealth, on April 27, 2026, Judge Doolin ordered that the civil litigant and her attorneys could only use the information from the former trooper's cell phone in connection with a separate potential action referenced during the hearing against the MSP and Canton Police. Translation. In the Karen Reed new filing, the new complaint that Karen Reed filed, Plymouth County, I think it's Plymouth. Is it Plymouth County? Bristol County? I'm getting too confused right now. Against MSP and Canton. That's the civil litigants that they're talking about here in this footnote, footnote 5. Karen Reed wanted to use portions of Proctor's cell phone extraction in her complaint against MSP and the town of Canton and its police department. And boy, did she. And if you think that that's all that's in there, I think you might be wrong. And it was explosive, and we covered that and so much more. The fallout from this is unbelievable. Could you have ever predicted this? I mean, I know we were hoping for it, but it's all happening. It's all happening. Yeah, right. Will someone order the code red for Proctor? Whatever Proctor can say in open court is a threat to everyone that has or had been protecting Proctor, Custer Crazy Horse says. And Mon says, the walls are crumbling brick by brick. I think we're going to have a lot more information sooner rather than later. I agree. It's huge. It's huge, says Patricia Dahl Yoga. On May 8th, 2026, defendant Myles King filed a second supplemental motion to dismiss, which is premised on information from the former trooper's personal phone. That motion is presently impounded. Under our common law, once a document is filed in court, it is a public record unless a statute or court-ordered rule directs its impoundment for good cause shown. Citing some cases. This presumption of public access to judicial records allows the public and the media to develop a full understanding of a judicial proceeding so that they may keep a watchful eye on the judicial system. Discussion. So this is the Commonwealth's motion. And at the end, we're going to see Rosemary Scapacchio signed off on it saying, oh, I agree. I agree. I fully support this motion. Discussion. Because the second supplemental motion to dismiss is impounded, the Commonwealth has been unable to specifically discuss it with the family of victim Marquise Simmons and explain the significant development in the case. Even the Commonwealth realizes this is a significant development in the case. We may not be able to get a conviction against Myles King because of what's in Michael Proctor's phone. Because the information in the phone materials is critical to understanding the claims raised in the defendant's second supplemental motion to dismiss, the second supplemental motion should not be subject to impoundment. Footnote 6, which reads, the defendant's 31-page second supplemental motion to dismiss does not implicate any concerns as to the privacy of third parties not involved in communications on the phone. However, the thumb drive submitted with the defendant's motion does implicate privacy concerns of third parties who are not involved in communications on the personal phone, as the phone also contained images and identifiable information that are not relevant to defendant's motion. The attachments to the motion should not be unimpounded or made publicly available without redaction of personal identifying information. So it seems to me that in the body of the motion to dismiss are a lot of quotes from Proctor's phone in support of the argument to dismiss Myles King's case. So if Judge Doolin does agree to unimpound that motion, we're going to find out a lot more about things that Michael Proctor was saying and or sending voice memos about, and or, according to the hearing, WhatsApp messages, Snapchat messages. I don't know if you saw it, but I put in the chat, Snapchat, what is he, 12? Everyone thought that WhatsApp messages were, I don't know, self-destructive and you can't get them. But apparently they do have WhatsApp messages and Snapchat messages of Proctor. Can you imagine if, and this is a complete and total hypothetical, because we know from Karen Reed's filing that Michael Proctor did say something like, I just want to stick a nightstick up his butt, plant a bag of Coke on him and tell him you're going in. What if he was talking about planting evidence on Myles King? He said other things that Karen Reed exposed in her filing, like, it's punch an N-word in Canton Day. Come get your retribution, or something like that. Hold on a second. I don't know, but I just scheduled this live stream, Cinnamon Bits. I just scheduled this live stream literally 15 minutes before I went live. So YouTube has a lot of issues right now, including member emojis not being available on iPhones and maybe other mobile platforms too. I'm not sure, because I can't even from my phone send member emojis to you. It's insane. So they want to unimpound the motion to dismiss. And if they do, if Judge Doolin agrees to it, we're going to find out a lot more things, I think, that Michael Proctor said that I don't know. Do you think that how much worse could it be? See, Reed versus Secretary of COM, READE, different case, 2015. Because information is in impounded materials critical to resolution on appeal, SJC lifted order of impoundment. And another case, Adams v. Adams, because information necessary to resolution of case, order of impoundment vacated. Modification of the court's protective orders is necessary for materials from the personal phone to be included in a public filing, as the filing will be given to the clerk, who will docket it and make it available to the public. Conclusion. The Commonwealth moves that the court orders be modified to the extent necessary to unimpound the defendant's 31-page motion and attachments, and that personal identifying information, phone numbers, WhatsApp, social media handles, be redacted from attachment B before any lifting of impoundment. WhatsApp, social media handles. So there's WhatsApp messages. And one of the attorneys did also mention Snapchat in the hearing, which if you weren't here for, you can rewind and watch it. We watch the Zoom live. Because it contains information, private information about third parties unrelated to the issues raised in the defendant's motion, including images of intimate body parts of third parties and discussion of an SA victim, and highly personal and personal identifiable information of third parties, the USB drive should not be unimpounded at this time. Counsel for the Commonwealth has conferred with counsel for the defendant, who has indicated that the defendant assents to this motion. XOXO, Jennifer Hickman, ADA, Norfolk District Attorney's Office, Canton, Mass. Assented to, meaning I agree, let's do it. For the defendant, Myles King, Rosemary, our queen, one of our queens, Scapicchio. We love Rosemary Scapacchio. She's a spitball. If you didn't watch Trial 4 on Netflix, I hear it's really good. Watch it. I haven't had a chance to yet, even though I get asked at least 10 times on stream. Every time I haven't watched it yet. I know I'm so negligent. If you weren't here before, we covered this earlier, but since it's very short, we're going to cover it again. Here is because, of course, Michael Proctor's attorney had to come in and oppose that motion, even though Michael Proctor's name wasn't even mentioned. I guess he was served with it. And so he had to oppose it. And his attorney was sitting in the dark, maybe in more ways than one. And this is Michael Proctor's limited opposition, but it's not really limited because it seems that he wants his privacy. Michael Proctor says, I want the court to deny the Commonwealth's motion that Rosemary Scapacchio agreed to. Again, this is in the Commonwealth v. Myles King case. As grounds, therefore, Proctor states the unimpoundment of said data would certainly compromise Proctor's privacy interests and possibly those of other individuals referenced in the data. I don't know, like the nudes and the intimate body parts contained in your, I don't know, group text messages are the faces of those women and or men contained in those photos. Makes me sick. Because you know, and this is public information, it's been out there, that the total phone extraction of Aidan Carney contained some nudes and or some videos, not only of Aidan Carney, but Lindsay Gattani. Are those in there too? Were they passing those around too? And it is my opinion, and it has been my opinion since we heard about this, that anyone who can be identified from those pictures should absolutely 100% be notified that their pictures have been passed around by Proctor and others and are out there. And I remember saying a long, long time ago, while we were covering Brian Walsh pretrial, I said, I think I said this when it first came out during trial number 1, when that came out about Proctor, no nudes yet. I said, do you think this is the first time he was looking for nudes? Do you think maybe there's a file somewhere of nudes of all kinds of people? It's amazing to go back and watch some of my old streams because there's so many things that I thought at the time that are now coming true. And all of you guys thought it too. And none of you, I don't think, were brainwashed by Aidan Carney. I think you came to your own conclusions. As noted in the Commonwealth's motion, Proctor has previously raised these objections before this court. Yeah, he has. To no avail, because Doolin was like, yeah, no, Karen Reed's team is getting it and they can use it in their complaint. While Proctor understands the appropriateness and necessity of communicating in a forthright manner with the victim's family members about the nature and context of defendant King's motion to dismiss, footnote 1, which reads, Proctor also recognizes and assents to the Commonwealth's efforts to keep the USB drive under seal. Well, I guess that's the part that he's not opposing. He agrees that by all means, the USB drive containing his total phone extraction should absolutely continue to remain impounded, as well as the Commonwealth's efforts to redact phone numbers and other personal identifying information. Well, that's the part that he agrees with. He's just opposing anything else that could possibly violate his own privacy. Proctor has legitimate privacy interests at stake surrounding the unimpoundment of this sensitive data. Unimpoundment of defendant King's motion will only add further public scrutiny to Proctor's private cell phone data and would result in a further and unwarranted intrusion into Proctor's private life. Wow. Wow. We really wouldn't want to jeopardize your private life or intrude into your private life when there could be many people sitting in prison because of, I don't know, planted evidence or bias, racial bias, misogyny, anti-Semitism. Maybe some cases weren't really investigated properly because of your bias. But by all means, sir, we're all worried about your privacy. It's mind-numbing. I can't imagine how much money he's paying his attorney. But to go back to the prior motion that we just read, right after Michael Proctor's union attorney was given a copy of his phone extraction, you may remember Michael Proctor was trying to get his job back. He was appealing the decision of the Massachusetts State Police to terminate him during those post-commission hearings. Right after that phone extraction was released to his union attorney, he was dumped by his union attorney. And the very next day, I think it was even a Saturday, Michael Proctor signed off withdrawing his appeal. Do you know how hard it is to get fired from the Massachusetts State Police? Do you know how hard it is to get abandoned by the police union? Well, I guess Michael Proctor is an overachiever because he did both. Wherefore, Mr. Proctor respectfully requests that this court deny the Commonwealth's motion. What about the intrusion into Karen Reed's private medical information? What about that, sir? You didn't think that was important when you were on the job? Mind-numbing. Mind-numbing. And I can't, there must be pretty explosive stuff that he said specifically about Myles King and that phone. Because remember the other thing that Karen Reed put in her complaint? There was a voice memo to Sergeant Good, I think, where Proctor said, yeah, I just passed by an accident that just happened. You might want to get over there if you're on duty. But you know what? There was an N-word involved. So in no rush, let them die. Let them die. What if, I mean, I'm just speculating again, we're just spitballing together, right? Marquise Simmons, what if, after the call for that shooting came in, they didn't rush over there, right? Because I think Marquise Simmons is black. So did Proctor say, no rush, let him die. Just spitballing. I mean, I rarely get speechless, but there are some times when I do. And I don't know, could this be one of them? Probably not. But let's take a look at the letter that was written by the public defenders to Michael Morrissey, dated June 9th, 2 days ago. It just became public yesterday by the chief counsel over there. And let's see what they want from Michael Morrissey. Shall we? We shall. I'll try and enlarge these for you as much as I can. They're JPEGs, so I can't highlight for you, but I think you're okay with it. And this is a letter written by Chief Counsel for the Committee for Public Counsel Services, Anthony J. Benedetti, on June 9th, 2026, to the Honorable, and I use that term loosely, Michael Morrissey, District Attorney for Norfolk County in Canton, Massachusetts. Dear District Attorney Morrissey, I am writing in light of the recently filed I am writing in light of the recently filed civil complaint listing virulently racist, sexist, anti-Semitic, homophobic, and hateful text and audio messages exchanged by Michael Proctor and Sean Good. See the attached complaint in Reed versus MSP and Town of Canton. It was Bristol Superior Court, filed on June 4th, 2026. There are also allegations in the complaint that Proctor messaged at least one fellow officer, if not more, about planting evidence on suspects. There it is. There it is. According to the complaint, the Massachusetts State Police were aware of these messages at least as early as February 2024, but did not investigate, discipline, terminate, or otherwise punish Proctor, nor take any steps to examine whether his bigotry was impacting his police work at that time. Also, prior to joining the MSP, Proctor shared his reprehensible views with other law enforcement officers, presumably at least members of the Canton PD, if not other agencies. There is no question that such messages demonstrate bias and misconduct by the officers who sent them, and therefore constitute mandatory discovery under Rule 14 of the Massachusetts Rules of Criminal Procedure. Items favorable to the defense include any information reflecting bias or prejudice against any class or group of which the defendant is a member. It is my understanding that your office agrees that these types of texts are exculpatory evidence requiring disclosure and already notified counsel for defendants whose open cases involve Trooper Proctor of his abhorrent views. So yeah, it was only released to open cases, defendants who were awaiting trial. They want more. They want it all in the interests of justice and fairness. However, more must be done. In Graham versus DA of the Hampton District, 2024 case, the SJC held that the Department of Justice's findings of misconduct within the Springfield Police Department unquestionably triggered the Hampton County's DA's office duty to investigate. Hold on while I pull up the next slide of my PowerPoint presentation. The opinion also discusses additional obligations regarding the disclosure of evidence to impacted individuals. So any impacted individuals. Thus, it is clear that the text messages from the U.S. Attorney's Office for the District of Massachusetts and from the Massachusetts State Police triggered your office's duty to investigate, disclose exculpatory evidence, and identify all impacted individuals. To ensure that all impacted defendants receive the evidence to which they are constitutionally entitled, I ask that your office take the following steps. 1, review the contents of all text messages in your office's possession to determine if there's any information reflecting bias or prejudice by other officers besides Trooper Proctor. It is clear from the attached complaint that your office is in possession of materials that demonstrate bias by Officer Good and that there may be others. See complaint at pages 16 to 18. 2, identify all cases, both open and closed, in which these officers were involved. Wow, can you imagine? Proctor's been with the Norfolk DA's office, MSP, since when? 2012, I think. That's a lot of cases. 3, notify all impacted defendants of this exculpatory evidence. All of them. Every single one of them. Think about all the people who might have taken a plea deal based on bogus evidence and the ramifications that they suffered even by taking a plea deal. Wow. What exactly? Somebody said, why didn't Morrissey resign? I don't know. Great question. Sergeant Good resigned. In Graham, the Hampton County District Attorney notified defendants with open cases through their attorneys of the existence of exculpatory evidence and provided access to the exculpatory evidence. CPCS provided notice directly to defendants with closed cases, and we would be happy to do the same here. Just give us the list. We'll notify everybody. You don't even have to do that part. Just give us the list. We'll do it. Good as that 18 years, says Melissa. I have a stress ball that I'm squeezing to death in my lap. In order to do so, we ask you to provide us with the following information. 1, a list of docket numbers of all open and closed cases in which Michael Proctor was involved since he became a member of the Canton PD and later with MSP. Wait a minute. Was Michael Proctor ever with Canton PD? Did I miss that memo? Only if you really know the answer. Yeah, Quilting Queen at the 5 o'clock show. We're going to go over the Adam Montgomery, the decision by the New Hampshire Supreme Court, 5 p.m. I'll teleport you over there so you won't miss a thing. She says, please, once you have time, please explain to me why Adam Montgomery's murder verdict. Yes, Adam Montgomery has been granted a new trial by New Hampshire Supreme Court. That will be in the 5 p.m. show. Does anybody know if Michael Proctor was with Canton PD ever? I didn't know that. But here's what they say. They're asking for, number 1, a list of docket numbers of all open and closed cases in which Michael Proctor was involved since he became a member of the Canton PD and later with the MSP. I didn't know that. This may be an error, but I don't know. 2, a list of docket numbers of all open and closed cases in which Sean Good was involved since he became a member of the Canton PD. And 3, a list of docket numbers of all open and closed cases for any other officer for whom your office has evidence of bias. I appreciate your attention to this request and look forward to your response. XOXO. Anthony J. Benedetti, Chief Counsel. I mean, they have an obligation to investigate, and they didn't. And do you think that Michael Morrissey wanted to? Wow. That was the letter. You think Michael Morrissey's going to do it? I mean, he's the district attorney through the end of the year. It's wild, but it's not really that surprising, is it? It's not really that surprising. Oh, good luck at the dentist. Amanj, thank you. Thank you for your super chat. Good luck at the dentist. This was during the hearing. This was hilarious. The Ghost 4282 said, citing Pretty V Please. Right. Michael Proctor's privacy is so important. Pretty V Please is the case site for that. Well done. Lost and Stuck in Detroit said, I'm willing to bet there's a lot of illegal things he's admitted to on his phone, which is what scares Proctor the most. He's probably admitted to planting evidence hundreds of times. Hey, Red wants to know, why is his attorney sitting in the dark, which made me think maybe he's in the dark in more ways than one. Kim is Ladybug says they are protecting Tully, Fanning, and Buchanan and others he texted with, in my opinion. Thank you, Kim, for adding in my opinion. And I think many people feel the same way. Overruled, sit down, says I'd ask for everything good was involved in. Also, they did. Look, they just did. Well, that's the public defender's office. But yeah, well done. Thanks for being here for 19 months. Raider Kev says, what adult uses Snapchat? Exactly. Is anybody here in the chat that is over, I don't know, 21 that uses Snapchat? But people think that Snapchat messages disappear. And so maybe that's why he was using it. I don't know. Can't speculate. Everyone hit the like button while we're here and while you're thinking of it and while I'm thinking of it, and helps the algorithm because everyone needs to know about this. Cupcakes for Justice. Thank you for gifting 5 memberships. You are the sweetest P ever. Known to 3 gifted 5 memberships too. Oh, thanks you guys. I love you so much. And Quilting Queen, also not to be outdone, is also gifting 5 memberships because you're amazing. Annie coming in with a super chat from across the pond. And her opinion is that maybe Beverly Canoni could be next. Thanks, Annie. Kimini Cricket says, when will you finish Turtle Boy's amended complaint? As soon as I have a minute to breathe. You'll know when I know. I still have to do some work on it because I still have to, it's a whole thing. Yesterday was Dave Day. Yesterday was Dave Matthews Day. There was no way I could go live yesterday. My full day was in preparation for and getting to my date with Dave Matthews at Forest Hills. So this happened today. And then at 5 o'clock, we're going to do Out of Montgomery because that's fresh off the press. The other thing's not going anywhere. Plus, it's going to take a long time because the footnotes in that one are lengthy. The videos are lengthy, including, well, we're not going to watch the full 12 hours of Turtle Boy's fundraiser stream, but we're going to have to watch the part again with David Yannetti because that's the part that they're closing. That's the part that they're citing, even though they don't timestamp anything, and many of the links are now dead because of the multimedia campaign to take Turtle Boy's channel down and others. Let's take a look at some other things that I had pulled for you that I find interesting in this same vein of Michael Proctor. Proctology. This is proctology class. And there's so much to see. Talk amongst yourselves for a minute. So the judge in the O'Keefe versus Reed case has issued a couple orders. Because remember, I think he was not happy the other day when he ordered Michael Proctor's deposition to be done the next day. And then Karen Reed's attorneys were like, yeah, no, we're not available. So now it seems that Michael Proctor's deposition is going to happen, I don't know, maybe June 25th and another July date. Let's take a look at those orders. One moment. Who sent it to me? Thank you, Betsy, for your Venmo XOXO. Love you so much. She just says disgusting. Oh, really? Well, I mean, listen, Kyle Sharkey is on it. It appears that the Commonwealth's assented to motion to unimpound defendant's second supplemental motion to dismiss has been allowed. Unimpound Town is here, friends. Unimpound Town is here. We like receipts. And Kyle Sharkey always has the receipts. And here it is. Here's the receipt on that. I don't have the decision yet, but it has been allowed. And so we're going to get to see it hopefully soon. Who knows? Sometimes things happen right while we're here, right while we're on the stream. Let's go to the receipt on that. News breaking in real time. Here it is. Commonwealth's assented to motion to unimpound defendant's second supplemental motion to dismiss is allowed after hearing and review. That was quick. That was quick. Parties to submit proposed redactions as to attachment B, but the entire 31-page motion is going to unimpound town. And this again is in the Myles King case, but we're going to get to see whatever it is that Michael Proctor said regarding Myles King. Yep. Doolin doesn't waste any time. He's on it. And he's I really like him, even though I don't even know him. I really do like him. Let's take a look. Tiff, I think you sent it to me, right? These orders? Let's take a look at the orders that were just issued. When I say just, I'm not really sure when, because I haven't looked at them yet, because, you know, we just fly by the seat of our pants here sometimes as things break in real time. Not everybody can do that, but, you know, you guys show me grace, so we do it. A lot of times it's a cold read, and a lot of times I get tongue-tied and twisted. Let's take a look at the orders issued just today, June 11th, by Judge Mark Gildea in the wrongful death lawsuit of the O'Keefes versus Karen Reed and the Waterfall. Order number 1. Counsel are requested to provide to Clerk Donovan by noon on June 12th, that's tomorrow, the following information as to depositions he or she has presently noticed on behalf of his or her client. The deponent, the date scheduled, and the time scheduled. Judge Gildea wants to know every single deposition that is on the calendar. Every single one. Because he doesn't want to have any more BS like they had the other day. He wants to know in advance when these people are supposed to show up in order to, you know, maybe like conserve some judicial resources. The next order. Oh, that's the first one. Sorry. Next one is 7080. Issued by Judge Gildea. Docket number 122. Massachusetts Rule of Civil Procedure 7A sets forth the pleadings allowed under the Rules of Civil Procedure. Massachusetts Rule of Civil Procedure 7B provides the rules applicable to captions, signing, and other matters of form of pleadings apply to all motions and other papers provided for by these rules. Such rules do not provide for letters from counsel. Doolin, what's right? Oh, I love that. Doolin, what's right? What? Thank you, Cher Louise. Well done. Love a good pun. Look at Doolin. Doolin, what's right? It is hereby ordered that the clerk's office shall not docket copies of letters from counsel. Well, so I guess the letter that Aaron Rosenberg was forced to send and publicly apologize for regarding the deposition of Colin Albert will be stricken from the record, because I think that's what the next thing says. So letters from counsel are not to be docketed anymore. And yeah, it is. It's exactly what I thought. Docket number 121 on the O'Keefe versus Reed civil matter says paper 111 did not include the requisite certificate of service. See Massachusetts Rule of Civil Procedure 5A. Any document filed through the court's electronic filing system must include a certificate of service pursuant to Rule 7A of the Massachusetts Rules of Electronic Filing. It is hereby ordered that paper number 111 shall be stricken from the docket. XOXO. Mark Gildea, June 11th. Let me just go back to my filings and see if I was right. That was 111, that letter. Hold on. Yep, that was Rosenberg's letter regarding regarding Colin Albert. So first he said, no letters allowed. We're not docketing letters here. We're not doing that. And the second thing he said was that letter 111 will be stricken from the docket. So it's as if it doesn't even exist. It was like he was forced under protest to file an apology. Jules says, we got to thank Alan and Karen Reed for this explosive and putting everything out there for other people that are in jail. Let's see how many people are locked up wrong. I mean, it's wild, isn't it? Is anybody surprised by any of this? Mildred says, it's much easier to get hired by MSP than be fired. That's true. And even Proctor said he was shocked when he passed the background check or whatever. He was shocked that they took him as a Massachusetts state trooper. I mean, we did read that, right? Thanks for your super chat. Deleted comment queen says, surely sharing people's private photos so that they can be passed all over the net is revenge corn. He's a criminal. No privacy for him. Love you, Melanie. Oh, I love you too. Deleted comment queen. That's a great username. John says, many men use Snapchat to trade certain pics with other men. Oh, I didn't even think about that. Kazmik says, hit that like button from Ireland. Slancha, my friend. Slancha, thanks for being here for 13 months. The good Karen from Utah has been here for 8 months. Thank you. And Chris Cardell says, Proctor only worked closely with Canton PD and John O'Keefe investigations and obviously sent many offensive texts to former Canton PD Sergeant Sean Good. Keep up the good work. Oh, thank you. Thank you. Nothing I love more than exposing corruption, even if people come for me and try and shut me up and dox me and say mean things about me on the internet. Kimmy Cricket says, can Proctor face criminal charges for planting evidence if he admits it and right? Yeah. Yes. Yes. Thank you for your 5. Surely. Absolutely 100%. Oh, please. So we covered that. That's wild. Okay, let me see. That's some pretty wild stuff from Judge Gildea, right? He wants to keep the reins tight on this case. He wants to keep the reins tight. He doesn't want to see other people weaseling out of their depositions. And, or, we still don't know what it was about Proctor, right? We still don't know. It was by committee. And it seemed like, I don't know what committees they have, if he's in a mental health facility or in a rehab, like, I don't know. But I mean, one of the first things I thought of is, what if he's like in witness protection? What if he's in WITSEC? What if he's in WITSEC? And that would mean that he can never come for a deposition because he's in witness protection. But I don't know. I mean, that was just kind of a joke. But then I'm thinking, what kind of committee would sign a letter? And then there was no CV attached, and the judge didn't like that either. But I mean, something like WITSEC would make sense, right? He can never appear for a deposition because if he's in witness protection, then he would come out and people would know where he was, and it could be a whole thing. Iche says it seems like it was the BS committee. I don't know. People say it has to be rehab or hospital. I don't know. Yeah, but you know how like so many people like who are accused of grape and other such things run off to like sex addiction camp to say that they're trying to do something about it. I have no idea. Whatever it was, they didn't think it was strong enough, right? So who knows? Who knows? I think Judge Gildea has had it. But that's my own personal opinion. I mean, in New York, what we do in civil cases is we go to a preliminary conference in court, we fill out a form, and we put dates in when all the depositions are going to happen. And they're at that point, the judge signs off on it, and then they are court-ordered depositions. And so the judge does know when the depositions are going to be. But I don't know that this is a routine thing in Massachusetts. And so I don't know. Can't speak to that. Because in New York, we have a preliminary conference, file an RJI, you get your judge assigned, and then you go in, you get a court order. So the depositions are court orders. And then when somebody doesn't show up, you don't have an issue trying to get a motion to compel or trying to get sanctions or whatever it is that you're trying to do to get that, to force them to appear for their deposition. And in other news, the Massachusetts State Police has filed an opposition to try and get them to turn over what? Let's see. Something. That's in the O'Keefe versus Reed case, but let me see one more second because I think there was some video that I wanted to show you. Yeah, this was it. So Rosemary Scapacchio tweeted something yesterday because there was an email that was released pursuant to a FOIA request. And the email says this. Here it is. This is from Brandon Hunt, who's like the FOIA guy over at the Norfolk DA's office. And it was an email from Adam Lally, March 14th, 2024, to Brian Tully with a CC to Laura McLaughlin regarding Commonwealth versus Karen Reed Rule 17 motion. Albert. And if we scroll down to the bottom, March 13th, Lally said to Tully, "No, thank you, but he's all set, sent everything for him to his attorney." And then it says above that, Tully to Lally with a CC to McLaughlin on Thursday, March 14th. The 3 motions have been served to the following attorneys. So this was back when I forgot that they tried to get Kevin Albert's cell phone records too, before trial 1, March 2024. They tried to get Kevin Albert's cell phone records too. Brian Higgins, Kenneth Berkowitz, and Kevin Albert. And it was scheduled for March 20th, 2024. And Tully said the 3 motions have been served to the following attorneys. So Tully was in charge of service. And it says Kevin Albert, attorney Rosemary Scapicchio, Brian Higgins, attorney William Connolly, Ken Berkowitz, attorney Damon Katz. And then Brandon said, "Thank you, sir." But Rosemary Scapacchio came out yesterday and said, "I have never, ever, have I ever represented Kevin Albert, and they know it." She called BS on it. Hold on, because you guys sent me a screenshot of that too. 1 second. Thank you, Tiff, as always, for being there with all the goods. And here's what Rosemary Scapacchio said. 6/10/2026 at 5:50 p.m. because now they're bringing her into it and she's not happy about it. Would you be? Here's what she said. Rosemary Scapacchio yesterday, 6/10/2026, 5:50 p.m. This is bullshit. I have never represented Albert in my life, and the Norfolk County DA's office knows it. Okay, let's go back because somebody posted, and you guys, as always, keep me apprised of what's going on over there. My old videos from, I guess, from covering that hearing. Like, I don't even remember back that far. All right. And here, the voice might trigger you. This is Judge Cannoni. All the way back in March of 2024, right before trial 1, all the way back in the day when I had a pink sparkly background. There you go. It's me watching me. Oh, I forgot about that truss. It's somewhere in my closet. All right, let me take my camera off because I hate watching me. Here you go. Here's Lally.
One done. The second motion that I'd like to start with is the defendant's motion for Rule 17 directed to Kevin Albert, Brian Higgins, and Brian Albert. Before we begin on this, Mr. Lally, is the Commonwealth opposed to either of the other 2 motions? Just a yes or no?
Yes.
Okay, and do we have third-party counsel here on either of these objecting?
Yes, I believe so.
Okay, all right, so I'll hear from you then, Mr. Yannetti, on your Rule 17 motion, seeking records from April 23rd to the present.
Thank you, Your Honor. With regard to this motion, Your Honor, Brian Albert was served.
One done. The second motion that I'd like to start with.
Okay, that's on a loop, but I had forgotten that they wanted Kevin Albert's records too. Had you forgotten? Let's hear that one more time.
Is the defendant's motion for Rule 17 directed to Kevin Albert, Brian Higgins, and Brian Albert.
Why did it say Ken Berkowitz in that email? Kevin Albert, Brian Higgins, and Brian Albert. Why did they say Ken Berkowitz? And why did they serve it on Ken Berkowitz? He at the time was the chief of police. Was he the chief at Canton? And then he went out on medical leave. And at the time that the murder of John O'Keefe happened, at the time of the murder of John O'Keefe, Ken Berkowitz was like supposed to be on medical leave or something, right? Okay, let's take this down because then there's another video that continues this one. Oh, please.
What the content of them were, which
Here it is. More Lally.
what the content of them were, which is the very epitome of a fishing expedition. And so for those 2 reasons.
Oh, look, there's Beauty Kelly Reed. Beauty Kelly Reed sitting there front and center.
The Commonwealth would submit that the defendant has not met the standard on the Lampron, and that motion should be denied.
All right, so I see Mr. Henning, so I don't know. Do you want to be heard? Yeah, please come forward. And I don't know who counsel is for Mr. Higgins, but if he or she's, do you want to be heard as well, sir? Great, so I'll hear you after I hear from Mr. Henning.
Good afternoon, Your Honor.
Good afternoon.
On behalf of Brian Albert, I just wanted to put three things on the record for the court. The first is, and I'm sure the court is aware, that the parties that are the subject of the Rule 17 motion have not actually received the motions. We got the cover page, we got the orders and the proposed orders, but we have not been able to review the actual memoranda because, at least according to the interpretation of the protective order, we're not entitled to see.
Oh, she's going to adjourn it. She's going to give them time to respond. You watch. This trial will never happen on April 16th if that happens.
That content. And that.
All right. I ruled that they were to be given because the federal proceeding is not to interfere with this court's proceedings.
I understand that, Your Honor, and I did receive the court's order, and I informed each of the respective counsel that I spoke to as far as what the court's order was. And I also understand that the court hasn't had the opportunity to review the federal protective order, but my interpretation of that order simply would not permit dissemination of the material contained within the memorandum.
Even though the Lampron Protocol says shall, doesn't that supersede a federal protective order? It's the law of the SJC. How can third-party record holders, the people who Rule 17 in the case law protects, not be able to go forward without it?
And I understand there's a direct contradiction there. And so out of an abundance of caution.
Okay, no, I understand you're following your order. I'm going to make it available. Not a party to any.
Did you hear her sigh there? Because we have a sigh emoji for that. Unfortunately, you can't use it because YouTube still hasn't fixed it. But listen to that sigh, the sighs of Judge Beverly Cannoni.
Protective order, but that
the federal proceeding is not to interfere with this court's.
Greg Henning, by the way, is also, a legal analyst on, I think, WBZ or one of those local stations. He represented, I believe, Brian Albert. Let's hear. I got distracted. I'm sorry. I want to hear what he said again.
For Mr. Higgins, but if he or she's, do you want to be heard as well, sir? Great. So I'll hear you after I hear from Mr. Henning.
Good afternoon, Your Honor.
Good afternoon.
On behalf of Brian Albert, I just wanted to put three things on the record for the court. The first is, and I'm sure the court is aware, that the parties that are the subject of the Rule 17 motion have not actually received the motions. We got the cover page, we got the orders and the proposed orders, but we have not been able to review the actual memoranda because, at least according to the interpretation of the protective order, we're not entitled to see.
Oh, she's going to adjourn it. She's going to give them time to respond. You watch. This trial will never happen on April 16th if that happens.
That content. And that.
All right. I ruled that they were to be given because the federal proceeding is not to interfere with this court's proceedings.
I understand that, Your Honor, and I did receive the court's order, and I informed each of the respective counsel that I spoke to as far as what the court's order was. And I also understand that the court hasn't had the opportunity to review the federal protective order, but my interpretation of that order simply would not permit dissemination of the material contained within the memorandum.
Even though the Lampron Protocol says shall, doesn't that supersede a federal protective order? It's the law of the SJC. How can third-party record holders, the people who Rule 7...
No. Do not get confused. Do not get confused. Karen says, why are we in front of Cannoni? I'm so scared for Karen. This is old. This is old. This is from 2024. Don't get confused. This is before trial number 1. We're taking a rewind here. Rosemary Scapacchio is calling BS, saying, I never represented Kevin Albert. What are you talking about?
17 in the case law protects, not be able to go forward without it.
And I understand there's a direct contradiction there. And so out of an abundance of caution.
Okay, no, I understand you're following your order. I'm going to make it available. Not a party to any protective order. So we can take a recess. You can have them now. What do you all want to do? I mean, I didn't know that the Commonwealth was not complying with my order. I understand why you didn't, but I didn't know that.
My apologies. I'm happy to be heard now, and if the court will allow us to review the motion and the memoranda, we can amend with a written filing if there's something.
Yes, pursuant to a protective order, the way we have them in the Massachusetts courts for Lampron Dwyer records.
Okay.
So.
Can I have one moment, Your Honor?
Yes.
Ooh, interesting twist, my friend. I thought she was going to adjourn it and give them time to respond, but he's saying, I can respond right now. What's his name? Greg Higgins? He's the attorney for Brian Albert. He's also the legal analyst that you guys were just telling me about. It's Greg Henning, Melanie. It's Greg Henning. Oh, sorry. I didn't mean to highlight that for too long because I don't know if I agree with your opinion, Suzanne. I just didn't want his name. Just for clarification, this goes back to, thank you to Leah Baker who tweeted this. said a Rule 17 motion was heard on March 20th of 2024. And it seems like Tully got one of 3 attorneys correctly. Brian Albert was represented by Greg Henning. Brian Higgins was represented by William Connolly. And Kevin Albert was represented by Peter Pisciuccio, or Pisciuccu. We'll continue this hearing. Or it's only a couple minutes long.
Your Honor, what I think the counsel for the third parties would ask is that we are able to address the court today, but allow us an opportunity to review the memoranda and submit something in writing before the court makes an order.
Delay.
Sure.
She's going to say, yeah, but I want it by tomorrow, like she would say to Yannetti and Jackson.
I'm just rereading the appendix on Dwyer, and it is a shall. So my view is that the SJC in Commonwealth versus Dwyer, the procedure that we're to follow allows, certainly, and I say mandates, that the third party record holders be given this information. So we will provide it when we take a recess today. I'll ask Mr. Clerk to make copies of what I have, not what the lawyers have. We need protective orders signed before you're given them. And I will have them given to all 3 record holders, or 4 if there's somebody here from Mr. Berkowitz. All right, I'll hear you.
Thank you. The first part of what I wanted to address is dovetails with what Your Honor was just addressing. The fact that we are third parties in this matter and do not have access to the materials that are in the subject of the discussion from the federal side of things makes us at a disadvantage here in front of the court. Obviously, we're going to remedy that, hopefully by being able to review it. But that notwithstanding, the fact that there's materials that we can't review that are being discussed in front of the court, even if we are able to see the memoranda, makes it difficult to address these. And I think for an issue of fairness, I want to make sure that the record's clear. If there are future motions, I want to preserve and not waive any argument as to the fairness of being able to access those records. So that would be the first point. The second point is, going into this, not having an opportunity to review the record, I do believe that the Rule 17 standard of relevance still needs to be met regardless of whether we get to see the material or not. So what I do want to offer to the court to consider as part of your determination here is that after receiving the notice from the Commonwealth last week, I contacted the U.S. Attorney's Office and I spoke to the lead prosecutor in the case.
Okay.
What I want to have the court know is that I have permission to notify the court that Brian Albert, his wife Nicole, his son Brian Jr., and Caitlin are not targets of the federal investigation. And I've been given permission to disclose that in open court.
Okay.
So I think it's important for the court to know that as you go into the motion that you're considering and the arguments from the defense.
Wow. Was that ever debunked? Because I don't know that the FBI ever tells anybody who their targets are or are not. But listen to what Greg Henning said that he was given permission by the feds to say that Brian Albert and Nicole Albert were not targets of the investigation. Listen to this again. This is wild to go back and watch this. Thanks, Leah, for posting this again.
I want to make sure that the record's clear. If there are future motions, I want to preserve and not waive any argument as to the fairness of being able to access those records. So that would be the first point. The second point is, going into this, not having an opportunity to review the record, I do believe that the Rule 17 standard of relevance still needs to be met regardless of whether we get to see the material or not. So what I do want to offer to the court to consider as part of your determination here is that after receiving the notice from the Commonwealth last week, I contacted the U.S. Attorney's Office and I spoke to the lead prosecutor in the case.
Okay.
What I want to have the court know is that I have permission to notify the court that Brian Albert, his wife Nicole, his son Brian Jr., and Caitlin are not targets of the federal investigation.
What? I want to know about who. I want to know who told him that. Who told him that? He's not saying who. And I call BS on that. I don't think that's ever done, Greg Henning. Because if they're telling you that, they're essentially telling the media that because you work for the media. You're not just Brian Albert's lawyer. You are the media.
And I've been given permission to disclose that in open court.
Okay.
So I think it's important for the court to know that as you go into the motion that you're considering and the arguments from the defense. The third thing I would like to just ask the court is, notwithstanding everything that's just been said and reserving the right to file that written document later on, Brian Albert does not object to turning over the materials that are being requested. I understand that the Commonwealth may be having objections as to the Commonwealth's case, but Brian Albert does not have anything to hide. He does not have anything that he needs to prevent the court from seeing this material. And if the court does deem, after reviewing the material and having access to the federal records, that these are somehow relevant, that these are somehow admissible. And the court deems that Rule 17 has been satisfied. Brian Albert will comply with the court order.
Thank you very much.
Thank you. On behalf of Kevin Albert, President is Peter Pasciuto, and on behalf of Brian Higgins is William Collin.
Great. Thank you.
Oh, who's going to be next?
All right, so counsel, I need you to spell your name for me, please.
Yes, Your Honor. The last name is Connolly, Connolly.
And what's your first name?
William.
Thank you. All right, I will hear you on behalf of Mr. Higgins.
Thank you, Your Honor. Your Honor, as the court is aware, Brian Higgins' phone records and communications are at issue in these motions. Brian Higgins is a federal ATF agent. He is a witness in the Commonwealth's prosecution of this case. And he has cooperated fully in the Commonwealth's investigation. As this court knows, we've not had the benefit of seeing the factual support for these motions, but I want to provide some information that likely isn't contained within those materials submitted to the court.
Wait a second. This is Higgins' lawyer, right? Oh, come on for a second. This is Higgins' lawyer. This is not, oops, I don't think this is the same lawyer who he had that, oh, I didn't get my hair cut. My hair is just up in a little twist here. This is just the front pieces that are shorter. So you're getting the illusion of a haircut, but my hair is really still here. Sorry. Remember when he first did his first interview where he printed up all his text messages illegally using the FBI equipment that his best friend Matt Kelch let him use to cherry pick his text messages between Higgins? It's not the same guy, right? So that attorney was the interview, remember, with Proctor was, and I think Buchanan was done at Higgins' lawyer's office. And then it turned out that he's married to a sitting judge. So it was done at a sitting judge's, not office, house, their home. And then what happened to that lawyer? And now he's got this lawyer. Things that make you go,
But I want to promote
again.
O-N.
Albert, President is Peter Pasciuto, and on behalf of Brian Higgins is William Collin.
Great. Thank you.
Connolly. Is Connolly the one who's married to a judge?
All right, so counsel, I need you to spell your name for me, please.
Yes, Your Honor. The last name is Connolly, Connolly.
And what's your first name?
William.
Thank you. All right, I will hear you on behalf of Mr. Higgins.
Thank you, Your Honor. Your Honor, as the court is aware, Brian Higgins' phone records and communications are at issue in these motions. Brian Higgins is a federal ATF agent. He is a witness in the Commonwealth's prosecution of this case. He has cooperated fully in the Commonwealth's investigation. As this court knows, we've not had the benefit of seeing the factual support for these motions, but I want to provide some information that likely isn't contained within those materials submitted to the court, but of which I have a good faith basis to believe is information contained in the materials provided by the federal government to the parties in this case. I have represented Brian Higgins since April of 2023, the month when he received the federal grand jury subpoena. Like he has in this case, Brian has cooperated fully with the federal investigation. He has answered every question put to him in both investigations, and he will continue to do so because he has nothing to hide. Brian Higgins is not a target of the federal investigation. That has been confirmed by the United States Attorney's Office and confirmed to me that I could make that representation in court.
Oh, really? So you were all talking to the U.S. Attorney's Office, all of you, Greg Henning and you. You were all talking to the U.S. Attorney's Office, and they all told you that Higgins and Brian Albert and Nicole Albert were not targets of the federal investigation. It's so interesting that they don't name names, right? I totally forgot about this. Wow.
The U.S. Attorney's Office has continuously confirmed throughout its investigation that Brian Higgins is not a target of their investigation. Brian Higgins has not participated in any kind of a cover-up or conspiracy to cover up the criminal activity of others. Brian has spent his career saving lives. He was a firefighter before becoming an ATF agent. He has been an EMT since 1992. He received a congressional medal for saving the life of a fellow ATF task force officer after being shot 5 times in Somerville, Massachusetts. He has served our military.
I didn't know he was shot 5 times. Did you know that he was shot 5 times? He was shot 5 times? Could explain some of his,
in Iraq. Participating after 1992, he received a Congressional Medal for saving the life of a fellow ATF task force officer after being shot 5 times in Somerville, Massachusetts. He has served our military in Iraq.
Thank you for your service.
Participating in a cover-up is contrary to who he is as a human being and a professional. I am here to represent Brian's interest in privacy. Brian Higgins, at my urging, will not capitulate and stand down when efforts are made to further intrude upon his privacy based upon sheer speculation.
Wait, what? The Worldwide Privacy Tour really started in 2024. That's when it started, the Worldwide Privacy Tour. Just like Harry and Meghan Markle of Canada. South Park, season 26, episode 2. We want our privacy. We want our privacy. We want our privacy. Wow. Crazy to go back and watch this stuff, right? Thanks again to Leah for posting this.
It is for that reason that we oppose these motions, not because Brian Higgins has done something wrong or has anything to hide. We know this court will give us an opportunity to review the motions and supplement our remarks if we deem it necessary. We know this court will fairly weigh the arguments before it and will render a fair decision, and we will respect that decision and we will comply with that decision. Respectfully, we do not believe there is a sufficient factual basis to support the relief requested in the motions before the court. Thank you, Your Honor.
All right. Thank you very much. Counsel?
Brian Higgins created electricity, says Cupcakes for Justice.
Good afternoon, Your Honor. Attorney Peter Paschuko on behalf of Kevin Albert.
All right, so you need...
No, this is Kevin Albert's attorney because they wanted his messages too. Imagine what's in Kevin Albert's phone. He would remember he worked for Can PD at the time. Wow. Oh, thank you, Boston Babe Forever. We just covered that a little while ago. We covered that. And thank you. Thank you very much for breaking the news that we already broke. I'm not calling you out, but I just think it's funny. Tell me you haven't been watching without telling me you haven't been watching. You can rewind, and I showed it. We already know. We already know. Psst, we already know. Okay, so Carmen Rose says, FYI, Meghan Markle is not Canadian. I know that Meghan Markle is not Canadian, but on South Park, she has to be from Canada, so they don't get sued for defamation. So that's a South Park joke. Sorry if you didn't get my reference, but that's what it's about. Here's Kevin Albert's lawyer.
You need to spell that last name.
Sure, it's P-A-S-C-I-U-C-C-O.
Good afternoon.
Yeah.
PIS.
Thank you. And just a little bit of background with respect to Mr. Albert. We are objecting to this Rule 17 motion. Kevin Albert's a 19-and-a-half-year veteran of the Canton Police Department, extremely well respected, extremely well liked.
Oh man, I feel like we got to go back now and find that hearing from March 20th of 2024, because that's where the clip cut off. Wow. Why would the FBI tell anyone they were targeted or not? They wouldn't, unless they were trying to give them a false sense of security, maybe. I don't know. They didn't come with receipts, you know? They didn't come with receipts. I mean, all of the things that we've been talking about for years are suddenly coming to fruition, it seems. Doesn't it seem that way? I don't know. Thank you, Poe Hunters. Villanelle says this is going to shake the county to the core. You can see it from all the way down under. Thank you. Dog Mom says, is there a Liar's Island? Will it be on Peacock? Maybe. Like Love Island and all the other islands. And John says, I wonder if we will see Proctor's Mike and Ike in the future. Thanks for your 5. Savvy Aries says this has become way more than an episode. Thanks for being here for 16 months. Oh, Kelly, it's not. It's just a twist. I didn't get a haircut, but thank you. But if you're saying I look younger, then maybe I should. It's really the whipped grass-fed beef tallow that I'm using on my face. I don't have any makeup on right now. No foundation at all. That's all it is. It's in my Amazon list. That's in the show notes below. It is whipped beef tallow. I don't know what the hell that is, but I got the vanilla orange flavor. And let me tell you something. It smells so good. And my skin has never looked better. And I'm old. Lisa Can't Stand You says individuals would not be the target. Norfolk DA's office is the target. Oh, thank you, Lisa. That is also true. Thanks for being here for 8 months. Ellen says, I hope Rosemary asks into the void, why did Lally write in an email that I was counsel for Mr. Albert? She did. She called it out on Twitter. She said, this is BS. I have never, ever, ever represented Kevin Albert. Why would they write that? Because why? Tully served the motion on that, her, allegedly. Because what happened to that hearing with Lally and Proctor that was continued but never happened? Right. The one that was in front of Judge Krupp. That was in the Myles King motion to dismiss. It was never finished. Now the second motion to dismiss has just been released into the ether, not the ether, the worldwide public, the 31-page motion. And as soon as I have a copy of it, we are going to get on the air and talk about it and read it together. Exactly. It never happened. You can see that all the way from Denmark. Ellen, thank you for your super chat. Music to My Soul says Betterow can relate to a Massachusetts court not wanting to accept letters. Oh yeah, that's true. He did get spanked for that once. Does it vary by jurisdiction? It might, yes. If it wasn't allowed in Massachusetts, it seems like Rosenberg would know this, so I'm not sure what to think. Right. Right. Well, I don't know why they filed it with the court. They could have maybe just sent it to the court without filing it with the clerk. Maybe they could have just sent the judge a letter, but I guess it was demanded by, I don't know if it was Diller or Colin Albert's Tuxbury. It seems like they were demanding an apology. I'm not sure what to think either, but thank you for your 10. And Joey 3 Sticks, when was this hearing? This hearing was, as was scrolling along the bottom, which you probably sent this $10 in before it was scrolling, March 20th, 2024. It was a Rule 17 motion hearing. They were trying to get the cell phone records of Brian Higgins, Brian Albert, and Kevin Albert, and she shut it down. I think she even shut it down like before the hearing could happen, if I recall, unless that was the Jennifer McCabe Brian Albert. There were so many pretrial hearings. The countless hundreds of hours that I have done on the Karen Reed case, it's all nicely organized for you in the playlists on the landing page of my channel. There's pre-trial trial 1, then there's trial 1, and there's post-trial trial 1, and then there's pre-trial trial 2, then there's trial 2, and then there's post-trial, and then there's everything else that has happened since season 2. You can go back and watch it at your leisure. It's good stuff. It's good content. And it's going to be wild to go back and look at some of the things that I said at the time that have now come to fruition. Tanny Sims says, beef tallow is rendered beef fat. You whip it with oil. It's easy to make. Well, I don't care. I love it. I love it. And I am promoting the company. They're not even sponsoring me, who makes it, in my Amazon list. And it's amazing what it's done for my skin. And I've used some very expensive face creams in the past. I've used them all to try and get some sort of, because as you get old, your face gets really dry. And so it's not the same as it was when you're in your 20s and 30s, right? And 40s. And I love it. I don't have any cows or anything, so I don't know how I would do that, but thank you, Tanny, for your 5. Phil says, you look younger now than last video, aging beautifully. I've also lost a bit of weight since then too. Because the Twitter trolls are, calling me fat and stuff. So I just, stopped eating. Aging beautifully. Can you imagine what was on those destroyed phones? No, I can't. I mean, I can imagine. Yeah, I can imagine. I can. What made me try it for the first time? It was in my feed. It was in my algorithm. It came up on like Instagram or something. And then I started reading about it. And then I couldn't find that brand that kept coming on my feed on Amazon. So I found another one that's locally, like it's made on a farm by a family, a mom who has 5 kids. And I was like, oh, let me try this. It's only $30. And I thought it was amazing. I think it's amazing. I still have yet to reach out to her because I have been so busy. But I will, because I would like her to know that we are supporting her family-run business from her farm. Thank you to Tiff for sending me some documents today that we have already looked at. And thanks, Em. This is my stream. All right, let's see if we can get to the part where this guy kept talking. Thanks, Em. Emily, you want a job? Oh, please. He really didn't say too much more after that. Let me just listen to it for a second. I mean, I hate to leave things half done and unfinished. That is one of my pet peeves. So let's go back and watch what Yannetti says after. And this again, March 20th, 2024. Thank you, Emily. See, I love you so much. And then we're going to take a little bit of a break before the 5 p.m. stream. And I'm going to tell you what happened with the New Hampshire Supreme Court and Adam Montgomery, that monster who was convicted of murdering his 5-year-old daughter, Harmony Montgomery, is getting a new trial. And I haven't even read it. It's going to be a cold read. All right, let's go back to this 2024 stream. Wait, that's not it. Hold, please. Not it. That is not it. All right, so this again is Kevin Albert's attorney, March 20th, 2024. It's only, look at that, it's only got 28,000 views. March 20th, 2024. This is my stream. We covered it live. This is how long we've been doing this for. We ain't got no quit. Over 2 years.
Albert, and we are objecting to this this Rule 17.
Okay, so this is Kevin Albert. We'll go back to the beginning of Kevin Albert's attorney's spiel.
CCO.
Good afternoon.
Thank you, Ron. Just a little bit of background with respect to Mr. Albert, and we are objecting to this this Rule 17 motion. Kevin Albert's a 19-and-a-half-year veteran of the Canton Police Department, extremely well-respected, extremely well-liked. Any insinuation that he participated in a conspiracy or cover-up is simply untrue. There's been no showing how personal communications between my client and Mr. Higgins have any relevance here, let alone evidentiary value.
We don't know that.
He's not a Commonwealth witness. He did not testify in the federal grand jury, and his involvement is essentially zero. This is a clear intrusion, as Attorney Connolly indicated, into
His involvement is essentially zero. Essentially. Not 100%, but essentially zero. How do you know? Did you look at his phone extraction, or are you just trusting what your client told you? Which lawyers do. They do trust what their clients tell you. But how about trust but verify? Attorney. Counselor.
to the privacy rights of these individuals. And I've advised Kevin that there's simply no reason to acquiesce to something that's just clearly a fishing expedition. So upon my advice, Kevin Albert is objecting to this Rule 17 motion, but we will honor and respect the court's decision and appreciate the time to supplement any response in writing after we see the motion and affidavit, which hasn't been provided to us yet.
Okay, thank you very much. All right, Mr. Yannetti, did you want to respond or no?
No, I would just move to the next motion if the court were ready.
Okay, so we'll move on to the next motion.
Oh my God, look who's in court. Queen Tanis Yannetti. Queen Tanis sitting with King David and Karen Reed in the middle. Well, I guess King David is not going to reply. So that is that. That is that. So we're going to come back to the present. We're going to come back to the present. And of course, that motion was denied. They got nothing. They got nothing. Good day, sir. Good day. Let us take a look before, because I really do need to fill up my drink before we start the 5 p.m. stream. Because, we don't do breaks here. We do little breaks here, but we stream as much as we can because we have so much information to cover. Bay Harbor Beauty saying that you've emailed me, no response. I thought I got an email of yours once, and I said I don't want you to send me any products because I don't give out my address and I don't have a PO box. That might have been a really long time ago, so I apologize. But again, I get hundreds of emails a day. My apologies. I don't know anything about. And again, Jules says Bay Harbor. See, then you're going to pay me $6.99 from Canada to come in and say, Melanie, Bay Harbor Beauty has been trying to email you to send out a PR pack. I don't give out my address. I don't give out my address. I'm sorry, but I'm not sorry. I am not sorry. I'm not sorry. And I guess something else that I'm going to have to put. All right. Never mind. People should know YouTube rules and courtesies. And like, if you come in there, if you come into someone's chat and you promote other channels or you promote your own products, it's like, it's not like the right thing to do. It's just not. If you come on here in the chat and you try and tell me who I should have on my show, who I should invite on my show, who wants me to go on their show. Don't do that. Don't do that. You know why? Because I barely have time to do my own shows. And if everyone's pressuring me to go on other people's shows, I can't do my own. And so I've been screwed by going on other people's shows, number one, and I won't allow it because I know you're not. I know you're not, but I love you. And I don't even know you and I love you. And I'm sure your products are wonderful and beautiful, but I don't give out my address. Somebody else, this is okay. So I'm going to play this for you because even though I said we're going to take a break, now we can't take a break because there was a person who was relentlessly harassing me on Twitter back in January 2024. And that is all relentlessly attacking me. It was a Twitter, and that's why I left Twitter. Cause I'm like, within 5 minutes of it, I was like, I don't have time for this. Okay. I don't have time for this. And then somebody found the old clip of me telling what was going on from all the way back in like January of 2024. I don't even know if I want to play it right now because it's very triggering to me. And this person had been posting shit about me like TikTok, 5 o'clock. I'm going to start releasing all your private information at 5 o'clock. Pictures of my house and shit, pictures of my mailbox, pictures of my kids. Yeah. January 2024. The name of the account was Waiting on Angels. And then I posted something after I started seeing this and everyone was sending it to me. And I was like, okay, who is this person? This is back when they thought I was Haley Walbrecht and I was going to release because Haley Walbrecht's account on Twitter was threatening to release Lindsay's phone extraction. And so everyone started coming for me, including Grant Smith Ellis. Okay. And I've forgiven him, bygones, whatever. I got to send him a sweatshirt. He hasn't sent me his own address yet. And I'm not going to accept it from anybody else because nobody else should be giving out anybody else's address without their consent. So the person I've been posting all this shit, like TikTok, it's 5 o'clock. I'm coming for you. I'm going to start releasing all your information. Started releasing pictures from my kids' Instagram. Okay. It wasn't my Instagram, by the way. It was my kids. And a picture of like the college name. And at the time it was a college that we were visiting. Okay. Thinking that they were trying to shut me the F up. And so when this troll was coming for me, I posted something on YouTube and I said, if anybody knows who this person is, let me know who this is because this is outrageous what's happening to me. I mean, I had the police involved, everything. And it was vile. And that's the reason I don't give out my address. But let's go back to it because since everyone wants to bring this back the F up, this is from January or maybe a little bit after in 2024. And this is the lore of how long they've been coming for me. And some jackass named, I'm not even going to name the name, that says, Melanie Little doesn't know how the internet works. This is what it looks like when you create an intentional echo chamber full of people you lie to because you can't handle criticism and also believe those same people who are forced to say you're classy. LOL. Here it is. Here's my rant from 2024. Because you might as well go back and look at it. All right. Well, I can get it a different way. Here we go. You worry, my friends. Don't you worry. Where's the video? But before we go there, we're going to also talk about the federal law against doxing. Okay. Because that's some interesting stuff too. Yeah. So, I told you earlier that there was a threat against me yesterday, a very credible threat, in fact. And it's been handled. January of 2024, I think this was January of 2024 is being handled. I am going to tell you this. I'm going to be classy about this right now. Okay. And I am going to, because that's the kind of woman that I am, unlike some other people. If anyone knows who this person is on Twitter, IP addresses and stuff are easy to get and, all that stuff is in the works. But anybody who knows who this person is on Twitter, who is convinced that I am somebody on Twitter called Haley Walbrecht, which I am not. I deleted my Twitter. I don't know who Haley Walbrecht is. But when you start posting things like TikTok, 5 o'clock, I'm going to start releasing pictures of your house and I'm going to release your address and all of your personal information, that becomes a federal crime. Okay. You know who you are. You know that you are watching, and I am going to give you an opportunity to take that shit down. Okay. I'm going to give you this opportunity because I have class like that. Okay. And when you start putting on there, it's so funny how the trolls have like repurposed my old rant from 2024 as if what I'm saying is not true. Where's common sense investigator? Am I wrong that IP addresses can be obtained? Is it impossible to do so? This unhinged thread about me and how this stuff is so disgusting that I'm not even going to read it because it is foul. It is absolutely foul. It goes on for what seems like days. And then at the very end, you say, so here's the thing, Mel, I do have a lot of private information about you. Seriously, you are way too open for someone who still has children at home. Because of that, I just can't be the one to put the rest out there. I can be an a-hole, just not that kind of a-hole, of course. Again, this goes back to 2024. This is when they first started coming for me. I didn't start talking about Karen Reed until January of 2024 when I went on Court TV. And right after that is when they started coming for me hard. And it's out there that perhaps they were being put up to it by certain people on the anti side. Perhaps, some people in the family. I don't know, but they tried so hard, and this is wild. It still triggers me to watch this because it reminds me of how this affected my family. This person did not actually not say those words. I did think you might actually care more about their safety than I do, but yet again, not Haley wins. I should have known. You act like a savior while things around you go neglected. You're no savior. You're a tormentor and a narcissist. I don't know who you think I am. I don't know you. I've never met you. I have done nothing to you. And I'm going to give you the opportunity to get that shit off of Twitter now. And I'm also going to ask you nicely to take down all the videos that you posted of mine where you stole my content and you made a little YouTube channel all about me. Okay. Oh, yeah. Before I copyright strike you. Right. I think she also started a Melanie Little Bad Actress Twitter account. There's also a Twitter account out there now called Melanie Shittle. And it's that this person thinks I'm a man. Remember when Nan went on somebody's and super chatted somebody saying that I have a dick? Do you remember that recently? Nan Gallagher? Yeah, she did that. So I have my ideas about who Melanie Shittle Twitter account is, but this is insane. This has been going on for years because I am done. You have been asked nicely by this person that you think I am, who has already agreed to testify for me in court. Right. That was Jason Broyles. Come for me and my children. You're going to have a problem, lady. If you are a lady, you say you're a grieving mom. And I posted something about you once and I took it right down because I felt bad for you. Right. I posted on YouTube, I think. I don't recall because I took it down. If anybody knows who this person is, let me know. This person's threatening me. I don't even remember what the post was because I took it down because I felt bad because she said that her kid had been killed or she was a grieving mother or something like that. And if you are a grieving mom, then my heart breaks for you that you lost a child. But how dare you come for me? This is a federal crime. You don't know what you're doing and you need to get control of yourself. Got me? You feel me? Disgusting. The trolls went nuts because I was going nuts. They were like, what does she think this is? This is the internet. People can say whatever they want to say. They don't realize that true threats are not protected and can be defamatory and can be prosecuted should someone decide to go to the police or civilly. People don't get the law. They don't understand it. And they think that they can do whatever they want behind fake names on the internet. And it's gross. Thing. And I'm not tolerating it. Yeah, Gloria, these people do not have feelings. And you know what? I'm going to handle it. I'm going to give her an opportunity to take this shit down. But yeah, this is, I mean, they were true threats. They were true threats. It was wild, but it triggers me, so I can't watch it anymore. Thank you, Andrea, for your 5 says, I emailed you with something breaking. I have not been here the whole stream, just saying it's a different topic. Okay, awesome. I will have a chance to look at that when I look at my 400 other emails. And if it's something that I want to talk about, I'll talk about it. But right now, we only have 6 minutes to get over to the next stream, and I really, really need to go hydrate and get my fill up my drink. So we're going to cover the New Hampshire Supreme Court decision on Adam Montgomery getting a new trial in about 5 minutes. I may be a couple minutes late because I really do need to go fill my drink, etc. Make a phone call or two before, well, it's almost 5 o'clock. Maybe some places are open late. So that's what we're going to do. Thank you, Andrea, for your 5. I appreciate you so much. I'm going to teleport you right over to the next stream. So let's get on over there so that we can talk about this New Hampshire wild Supreme Court decision to give monster Adam Montgomery a new trial after his conviction in the murder of his 5-year-old beautiful daughter, Harmony Montgomery. Okay. I'll see you guys over there. I love you guys. I'll see you real soon. We didn't even do like the motivational quote we'll do it on the next stream. All right. Stay cool, stay kind, stay classy. Love you, mods. I'll see you over there. I'm going to teleport you guys. So just buckle your seatbelts because hopefully it won't be a bumpy ride. And I'm going to see you real soon in like 5 minutes. Okay. All right. Peace out. Bye.